And this finishes at 11:30. Can I welcome members of the public back to the room? I'm sorry for the temporary inconvenience of having to step outside. And could I also welcome our witnesses to the floor? We will now, as a committee, hear oral evidence from the following groups: the Criminal Justice Alliance, the Prison Reform Trust, the Howard League for Penal Reform, for whom we have 2 representatives. For the record, could I please ask our witnesses to introduce themselves in a big, loud, crisp, clear voice, so the Hansard reporters can pick it up, to the committee.
Cardwell, Director of the Criminal Justice Alliance.
Juliet Lyon, Director of the Prison Reform Trust.
I'm Frances Crook, I'm Chief Executive of the Howard League for Penal Reform.
Andrew Nielsen, Assistant Director and Head of Public Affairs at Howard League for Penal Reform.
Thank you very much indeed. Before calling the first member to ask a question, I should like to remind all members that questions should be limited to matters within the scope of the bill, and that we must stick strictly to the timings in the programme motion the committee has just agreed. I hope I don't have to interrupt mid-sentence, but I will do so if need be. Would any of the witnesses like to make a brief opening statement? It's not compulsory, but if you'd like to do so, you're very welcome. Juliet Lyon.
Thank you. I'd like to say that the Prison Reform Trust welcomes many of the opportunities and measures within the bill. I'm careful not to say all. In an effort, a valiant and useful effort, to try and sort out various messes that have occurred within the justice system, which we fear over years has responded to populist concerns, and the inflation in sentencing has led to undue pressure on the prison service, on other criminal justice bodies, and of course on prisoners and their families themselves. We think that the moderation and proportionality within the bill are to be welcome.
Frances Crook.
I would like to echo that, and the Howard League for Penal Reform does welcome many of the measures in here. It's very important to exert downward pressure on the system, because over the last 10 or 15 years it has, the prison system has sucked into it far too many resources and too much attention, and it's important to exert some downward pressure. So we welcome the general thrust, which we think is some of the tidying up is very important. We are concerned about some of the clauses in the legislation which I think are a bit muddled, and we, in a spirit of constructive discussion, we would like to offer some helpful suggestions to the committee as to how that can be tidied up.
Most grateful. Who'd like to be the first member to kick off with questions? Mr. Alex Cunningham.
Do I stand first? Sit down, please. My apologies to the Chairman, learning the procedure as I go, and it is a pleasure to serve under your chairmanship. Probation trusts across the country are facing severe cuts. What I want to know, is there capacity within the service and youth offending teams, for example, to manage the Bill's aspirations for greater community sentencing, and what the implications are for public and victim safety?
I think that is one of our concerns, is that the government does appear to be looking to make cuts across the board in the criminal justice system. We don't have a problem with cuts that are related to reducing the prison population, but we have to understand that does put pressure on the community end. And the danger, if we cut probation as well, is that we are setting people up to fail. And I think it's very important that money that is saved from reducing the prison population is reinvested into probation.
I think it's important to note that if the bill succeeds in reducing prison numbers to something like an unavoidable minimum, there is the prospect or possibility of justice reinvestment, and that would be something we'd welcome. It's a subject which the Justice Committee had turned its attention to last year. We would like to see monies freed up for proper work by probation and youth offending teams. I think it's a very important question. I think it's also important to note that youth offending teams have succeeded thus far in working effectively with young people, to the extent that they've succeeded, along with others, in reducing the number of under 18-year-olds in custody by about a third within the last 3 years. And that indicates the prospect for more work of that kind, particularly for 18 to 20-year-olds. But we would share your concern that in order to succeed, it will be to do with implementation, and it will be to do with adequate resourcing.
So you'd think there is a possibility for reinvestment? I mean, it seems to be a cuts agenda rather than a reinvestment agenda.
Well, we would encourage the committee to explore the possibility of that, because the bill will stand or fall, in our eyes, on whether, one, it succeeds in reducing unnecessary use of imprisonment, obviously not necessary use, and whether it's prepared to work on the basis of reinvestment in other criminal justice agencies. I think the last point I'd like to make is that not all the solutions are going to lie within the criminal justice system. There is some provision in the bill already. For example, the extension of local authority seeing under 18-year-olds as children in care once they enter custody. There is, I think, scope for more opportunities to alert local authorities as to their conjoint responsibilities. And that would indeed make a world of difference.
This session finishes in 35 minutes' time, and the following people have caught my eye and will go in this order: Elizabeth Truss, Andy Slaughter, Robert Buckland, Dave Watts, Kate Green, Elfyn Llwyd. So you know the time. Let's try and make sure everybody gets in. Elizabeth Truss.
Thank you, Mr. Chairman. You've talked about reducing costs outside the criminal justice system, but surely there is a lot of cost just in the process of the criminal justice system. And I wondered if you could identify any savings that could be made in NOMS and the structure of NOMS, and also in the cost per prison place, where savings appear to have been made by contracting out prisons. So could you identify savings in the cost per place and also the structure of NOMS that could contribute to the reinvestment in the justice system?
I think that small savings can be made by cutting regimes or by cutting staff numbers, but in the end that's not really going to make a huge amount of difference. Real savings can only be made by closing institutions and by reinvesting that money in community provision and community prevention, which we know for the majority of people who commit offences is a very safe and effective way of managing them in the community. That's where the costs have to be diverted, and that's where the better community provision will prevent people from committing future crimes.
Isn't it the case that the cost per place is very high in Britain compared to other countries' prison places?
Francis Crook.
I'm not sure that's true. I think it varies from prison to prison and from what kind of establishment you use. The cost in this country for provision for young people, for example, is very high. But you cut that at your peril. If you are going to lock up young people, the cost will be high because they have to be safe. You can't do incarceration on the cheap, because the consequences are more crime as a result.
Vicky Hellier-Cardwell.
The Criminal Justice Alliance would just add that the costs of reoffending in the system are extremely high, and the costs of reoffending of people who have come out of custody. And so we have long campaigned for community sentences that actually achieve a lower reoffending rate than often short sentences, custodial sentences, and there's significant saving that can be made from that move towards community centres as opposed to prison sentences.
Juliet Lyon.
Simply to add that the Ministry of Justice research shows that community sentences are now outperforming a short prison sentence by at least 7%. I think that's heartening news. I think there's further scope. But to answer your point directly, I'm very much with colleagues here that if you do reduce the £45,000 average cost of a prison place, or over 50,000 for women and considerably higher for children, you risk even higher reoffending rates. So it's a very short-term saving for a very long-term cost.
I think also
Andy Nielsen.
If we look at contracting out, the recent example is Birmingham. Birmingham is a very large prison, 1,500 prisoners with a lot of problems, and a succession of inspectorate reports have said that the problems in that prison are around safety and staff-prisoner relationships. These are both things which are related to the amount of staff in a prison, i.e. there are not enough. What we've seen is that the private contractor that will now be running that prison is actually cutting staff. So those problems will increase. So there are not just problems with reoffending, but problems actually in institutions which will be exacerbated potentially.
Andrew Slaughter.
Can I go back to finance? What you describe is a sort of virtuous circle whereby community, the money saved from prison places is invested in community punishments, which in turn may prevent reoffending, which in turn may save money. And there are some signs that that's happened in youth offending over the past, with places being taken out. What I suggest to you, and ask your comment on, is that what this bill is a vicious circle downwards, because the money is simply being taken out of the system, that we've got up to 10% cuts in probation services, an average of 18% cuts this year in youth offending teams. So do you not think that those services are being set up to fail, i.e. new responsibilities are being put on those bodies by this bill, but they're going to have many fewer resources to deal with them?
It certainly seems to us that we currently place far too much store on what imprisonment can achieve. And consequently, we would welcome the idea that prison would take, if you like, a disproportionate proportion of the cuts, if and only if numbers can be reduced. One would certainly not be arguing for fewer staff or less effective institutions, far from it. But it is true that until you close a whole institution, you can't make significant savings. And it seems to us that the Ministry of Justice should be working towards rationalising the prison estate, and on the basis of a thoroughgoing review make some very clear decisions about how many establishments they need, in what order those establishments have to be, and where they have to be sited. And that's where the savings will come. Without that, I think it's going to be very piecemeal and difficult to achieve.
I'd ask, perhaps the others may want to comment on this as well. Let's say those savings are made, those savings are going to the Treasury. What then happens? As I said, at very, very high levels of cuts, particularly in youth offending teams, what do you think the consequences are going to be in terms of rehabilitation, or the ability of those services to deal with, A, their current workload, or B, an additional workload? There are no extra resources being put in there.
That will put
Francis Crowe.
pressure on obviously on local authorities and other people. We would like to see, as I said, a downward pressure so that resources are diverted to prevention. I mean, I would much prefer the crimes weren't committed in the first place rather than trying to pick up the pieces afterwards. And if at the moment the criminal justice system puts huge resources into cleaning up the mess after, and actually tends to make it worse rather than better. And what we want to see is a downward pressure in prevention. In the youth justice system, we've seen that. We've seen not only fewer children going into custody, which in itself is actually good because it's cheaper and it's better for the kids and it's better for the community, but we've also seen a reduction in first-time entrance into the community and arrest rates. So we need a downward pressure all the way down. But you're absolutely right. The resources can't just be taken out of one place and put back into the Treasury. What's got to happen is that those resources have to be put into the prevention side, into children's services, for example, taking children as the example there, so that there is the prevention and the children's services, so they don't commit the crimes, they don't get into trouble in the first place. Fewer victims, less crime, fewer people in prison, safer communities.
I think the Criminal Justice Alliance doesn't necessarily focus on under 18s, but we do have a serious concern. We're a member of the Transition to Adulthood Alliance about 18 to 20-year-olds or 18 to 25-year-olds, which do consume a large proportion of probation resources. I think one study found it was about a third of probation time and resources were spent on this young adult age group. So there is a need in some way for investment in this age group, and perhaps a national strategy to ensure that we're doing the right thing by these older teenagers and young adults. So there is an issue there about reinvestment.
I could go on, but if you're happy for me to now, I'll come back at the end if others want to ask questions.
Thank you very much indeed. Robert Buckland.
Thank you, Mr. Holborn, and indeed it is a pleasure to serve under your chairmanship. I wonder if I could ask the panel this question. The lack of opportunity for prisoners to use their term in custody productively has been a real problem. I think we'd all agree. Does the panel welcome the proposed implementation of the 1996 Prisoners' Earnings Act? And if so, can it perhaps help shed some light as to why we've had to wait for 15 years for that implementation?
Can I answer that?
Francis Crowe.
This is something I've campaigned for work in prisons for 15 years. And I just think that long-term adult male prisoners should have the opportunity to do a day's work and should be contributing to society by paying tax. The Prisoners' Earnings Act was actually passed by my local Member of Parliament. I told him at the time I didn't think it was the right answer to the question, and I still don't think it is. I welcome the government's commitment to this. I think it's a fantastic opportunity. We could be showing the world how long-term adult male prisoners could be contributing, keeping their families, paying some contribution to victims' charities, doing an honest day's work for an honest day's pay, which rather than lying idle on their bunk for 20 years at a cost of £2 million to the taxpayer. So this is a problem, and the work in prisons is a solution. However, I would suggest that not only is the Prisoners' Earnings Act flawed, I think the clauses in this bill are misguided. It's not necessary. It's not necessary to have legislation on this. The powers already exist. In fact, I'm in discussions with a prison at the moment to start a business inside a prison and to do it. Legislation is not required. There is already the power within the prison service to allow people to work. They can be employed by outside companies, properly employed by outside companies, paid the rate for the job, paid tax. That way they wouldn't undermine or depress wages, nor would they be anti-competitive. The legislation exists. It is not necessary to bring in other legislation. So we welcome the government. We're very keen to work with the government on this. We welcome the proposals, but I don't think that the clauses in this bill are required.
Juliet Lyon.
We certainly welcome the idea that time should be well spent rather than wasted when people are in prison, and too often that is the case, that too little happens in prison, and a remarkable amount of time is wasted by sheer procedural efforts to keep the institution ticking over and keep it safe. We've recently done some research with prisoners and their families called Time is Money, when we've been looking at financial exclusion of people, both while they're in prison, when debts can continue to mount up, and when they leave, when they can't get bank accounts or they can't get insurance, or they leave with a discharge grant which can't possibly manage to last the 2 weeks since they leave. So I think that alongside the Prisoners' Earnings Act and the emphasis on responsible work in prison, we have to think about ways in which we make it impossible sometimes for people to take responsibility either in jail or on release from jail. The other publication we've produced is Time Well Spent. We've done a survey across the prison estate looking at opportunities for volunteering. This isn't instead of work, it's as well as work. But we commend to the committee the work of the Samaritan Listeners, the work of the Toe by Toe organisation and others, where prisoners act as mentors, prisoners take a tremendous amount of responsibility for saving lives and helping others. And we would like to see a responsible environment reserved for serious and violent offenders where they could engage and with staff trained appropriately and supported to encourage that kind of an institution. We're very far from that. I mean, that's the only caveat I'd like to add, is that although the bill is aspirational in this instance, I think we are a long way from achieving that. The average wage currently for a prisoner is between £8 or £10 a week, which is really woefully inadequate.
Vicky Hellion-Cardwell.
Just to echo that and say that we welcome the Work in Prisons agenda and the contribution to a victims fund. The only concern we wanted to raise around this issue was a subclause 1034C, which talks about the money to be paid to the prisoner before or after release on fulfilment by the prisoner of prescribed conditions. We just wanted confirmation and clarity that on release the prisoner, an ex-prisoner, would receive money that they had earned legitimately in prison, and that it would be unfair to add further conditions on prisoners. But we fully support the work agenda.
Roy Buckland.
Very, very quick supplementary. I was very interested in what Francis Crook had to say about the necessity for legislation, and as somebody who likes to hesitate before new legislation, I'm in sympathy with her. But is there not this point to be made, that in terms of the hypothecation of the earnings, because some of the earnings will be transferred hopefully to victims of crime, that some provision has to be made via amendments to the prison rules, which necessitates some legislation in the bill?
Well, as the only
Francis Crook.
The only person I think who's ever run a real business inside a prison and employed prisoners on a real wage, on the same terms and conditions as I was employed, including holiday pay and sick pay, we deducted tax. And we had a voluntary compact with our prisoner employees to deduct 30% of their net wages pay that into a victims fund. I think as a condition of being able to apply to go to a working prison, prisoners would sign up to having a proportion of their wages deducted to go to a fund for victims, which would be a symbolic in lieu of bed and board, because bed and board costs can't be deducted. So it is possible to do that. The important thing is that prisoners should be employed by outside bodies, not by the prison service. And this bill is replicating that flaw, which is assuming that it's the prison service that's going to be subcontracting the industries from outside businesses and then employing prisoners again. Prison service, with the best will in the world, cannot run businesses. They cannot employ people, and they've failed for 100 years, and they will continue failing. So we need to get outside businesses employing prisoners inside prisons on real wages, on real businesses in the real world. That way, you don't need the legislation at all.
We've got 20 minutes left of this session, and your evidence is generating, as it always does, more interest. And we now have 6 members lined up to ask questions in the following order: Dave Watts, Kate Green, Elfyn Quid, Ben Wallace, Helen Goodman and Damien Hines. So I'm going to ask each member to ask one question, and I think that way we'll get everyone in. And your answers are very interesting. Please can we keep them crisper and shorter so we can get all your evidence on the record. Mr. Dave Watts.
As a panel, you seem to be very much in favour of the government's proposals, providing the resources are made available to actually make it work, the increase in youth offending teams, probation and the workplace elements of the proposals. What do you think the effect will be if those resources aren't made available and you try to pursue the policy without having sufficient resources in youth offending teams, in probation and in the work environment?
I think we've already gone over some of this in earlier answers. There is a danger to reduction in funds for the system, but at the same time we do have to beg the question: is the system too large? Are we putting too many people in, never mind prison, but probation too? There is overcrowding in both systems. And it's the reach of the criminal justice system, the fact that it now takes in more people than it has ever before, the fact that it costs more than many other countries now. So although we are worried, I think all our organisations are worried about the balance of cuts, I think we do see scope for a much reduced criminal justice system, and I think that is an important point to make. That requires bold sentencing reform, some of which may be in this bill. It might have been bolder, but it's that bigger question about, well, what is the penal system, why do we use it, and who do we want in it, that we really need to ask as a society, and this bill is only the beginning of a debate on that.
Kate Green.
Thank you, Mr. Holborn. In your view, does the bill sufficiently recognise the special needs and circumstances of women in the whole of the criminal justice system, both pre and post-trial?
Juliet Lyon.
Spectacularly, the bill doesn't mention women at all, or possibly as a footnote, I gather. This is remarkable, given the work that was done by a number of bodies, including most recently the Corston Review. We believe firmly, and we have the findings now of the Women's Justice Task Force to back this up, that the number of women in prison could be reduced easily by the same degree as the number of under 18-year-olds, given the level of vulnerability, given the petty, persistent nature of much of the offending, given the need to work on addictions, enabling women to get out of debt and so forth. And the thing that we've seen that really has impressed us and the members of the Women's Justice Task Force has been a range of schemes outside of prison walls, particularly women's centres, where women can attend, continue to take responsibility for their children and address the particular causes of their offending. And they are showing very good results. So we think there are solutions. We regret very much that government hasn't chosen at this stage to indicate that it is prepared to take particular steps in relation to women. And we think there's a good case for a national strategy to reduce women's imprisonment and respond to their particular needs. We think there's a good case for much improved leadership on this issue, which I think is indicative of the fact that women haven't appeared in the bill, whereas you'll see a set of coherent clauses about youth justice, nothing about women's justice. That could be rectified.
Vicky Helier-Cardwell.
We would support the need for a national strategy for women and sort of championing of that issue at leadership level. I just wanted to flag up, in case we don't come onto it, the bail and remand provisions will have a positive effect on women. At the moment, 1/3 of women offenders remanded to custody do not go on to receive a custodial sentence. Well, that's hugely disproportionate, and often women are carers of children. You know, there's disruption to the family home, there's disruption to employment and caring responsibilities. So the CJA is supportive of the provisions on bail and remand in the way that they will impact on women for whom it is used far too frequently and with very severe consequences.
Mr. Elphinstrid.
Thank you, Chair. The bill as it now stands requires Justices of the Peace to decide whether, quote, there's any real prospect of a custodial sentence being imposed, but at the very beginning of the case when they decide on bail. How do you think the outcome of a case can be predicted right from the very start in that way? And do you believe that the provisions as drafted provide sufficient protection for victims?
Francis Crook.
This proposal, I think it'd be very helpful. The Howard League has long argued that there ought to be a provision so that when somebody is found not guilty, or has after a period of custodial remand, they should be able to apply for compensation. Because we are very concerned at the overuse of custodial remands. So anything that can exert a pressure to deter that from happening for a whole variety of different reasons, we welcome very much.
Juliet Lyne.
We welcome the provision in the bill. We appreciate that it might need strengthening or clarifying. But the reality is that currently over 55,000 people a year enter prison to serve a period on remand in custody. Of those, over 11,000 are acquitted. And around about half in total don't go on to serve a further custodial penalty. I don't think we can afford a system that is so hugely out of kilter with a fair and just and proportionate response. So this is a proposal that seems to us to enable the courts to think very hard about why you would need to use custodial remand and to not use it for some of the things it's been used for in the past. An instance would be remanding people to have a mental health assessment. There are other ways of doing that. There are other ways of ensuring that people turn up for trial. And it's a very timely review, in fact, way over time. So we would support it in broad terms, appreciating that there may need to be some clarification.
Ben Wallace.
Thank you. Can I just move on slightly to the IPPs? I mean, could you just give us your view? Because it's slightly the elephant in the room when you're talking about cost and waste as well. I mean, looking up 6,000 people, 3.5 who have already served their tariff with an open sort of lolling around in their cells is a vast waste of money, even if that money could have been used to re-educate them or do something else and cut off rehabilitation. What was your impression of the IPP policy as it stands now?
Juliet Lyne.
We very much support the review of IPP sentences and the proposal to bring the review and the findings from that back into the bill. This is another instance of a massive unfairness. In this instance, they're not lolling around in their cells, I don't think. We run an advice and information service that responds to about 6,000 prisoners and their families each year, very many of whom are serving an IPP or concerned about someone serving an IPP. Our experience is that people are chasing courses, is the best way of putting it. given that the only way out of a maze for many is to do an offending behaviour programme, they are trying to transfer from one prison to another, desperately trying to gain a place on a course. Somebody last week phoned us who is serving had a 71-day tariff, who's currently served 5 years, and is still asking advice on where courses might be available, when he might have a parole hearing. This is totally unacceptable. If I may, I just want to give you one other example, because I think it just concentrates the mind. There was a woman who went into Holloway Prison on remand. During that period of time, she set fire to herself and her cell because she wanted to kill herself. When she came to court, she was in fact acquitted of the remand charge, the offence for which she'd been remanded. But she was given an IPP sentence by the judge because he said that arson was a very serious offence and she might well commit that same offence again outside in the community. We don't know what's happened to her, but the odds are, I fear, that she may well be still serving that period of time in custody. It is Kafkaesque, it is unfair. It has attracted the disapproval and criticism of almost everyone in the criminal justice system, from judges to the Prison and Governors Association to staff who have to work and manage a system. And we would dearly love to see it brought absolutely under control and disposed of in its current form.
I think it's also a sense
Andrew Nielsen.
the public don't understand. I mean, if it was enacted with the idea of being tough on crime in mind, these people they're never going to get out, or they're certainly not going to get out until they've gone through many courses and proved they're safe. That hasn't worked. I mean, we've seen in very high-profile cases. I'll get the example. One example would be Baby P's mother, who received an IPP sentence, and all the media coverage focused on the minimum tariff. And so it seemed as if she was, I can't remember the exact figure, but she was going to serve 4 years, and the media focused on that and whipped up public outrage that was all she was getting, whether that's correct or not. And so it hasn't even worked in that sense. I mean, it is a sentence, as Juliet says, which is a complete disaster. Anyone working in the system will tell you that. The Howard League would say that it is wrong in principle because in the end you are locking people up not for what they've done, but for what they might do, and we believe that's unjust. But even beyond principle, it's practically failed. And it will, in fact, in a system where you will see budget cuts, there will be even less opportunity for people to do courses and even less opportunity to progress through their sentence. So we have to get the IPP abolished.
We've got 10 minutes left. One question each from the following three members: Helen Goodman, Damien Hines and Yvonne Verberg. Helen Goodman.
Thank you very much. Mandatory minimum custodial sentences are quite controversial, and I'd like to ask the witnesses whether they think what the impact of them is, whether they think they are an effective deterrent, and in particular what they think of the late addition to the bill, the new knife crime that's being proposed by the government.
Vicky Holier-Cardwell.
We would just make the point that we don't think mandatory minimum sentences are the most effective response to knife crime. We would obviously wish to see much more resources put into preventative services. And the other point we would make is that the Sentencing Council are doing some really useful and important work in clarifying and providing consistency around sentencing, and we wouldn't want to see anything that works against that important work that's being done. And also there seems to be very little evidence around the deterrent impact of mandatory minimum sentences. So we're not in favour of this. But obviously that is not to say that knife crime isn't an important issue. We just don't think this is the most effective response.
Francis Crook.
The Howard League published some research which was conducted by a prison governor on young men serving long sentences, some of them, for knife crime. And the evidence that came from the young men themselves was very clear that it's not the sentencing that is the deterrent. Actually, their lives were so chaotic and so violent, they were much more afraid of each other and being knifed than carrying a knife or being arrested. So I think sometimes mandatory minimum sentences constrain judges' discretion irrelevantly and do not have the desired effect, and in fact sometimes can have unforeseen and contrary effects.
And knife crime is also just as add, it seems strange to focus on this at a time when knife crime is actually on the decline. We've seen a decretion in offensive weapon possession of 23% between the beginning of 2009 and the beginning of this year.
Damien Hines.
Thank you, Mr. Chairman. I'd like to come back to the line of questioning Mr. Buckland made to Francis Crook about the clauses related to the Prisoners' Earnings Act. And I think you were saying that those clauses were not necessary to make further progress in this area, both in relation to the work itself, but then also both in relation to the victim support contributions and also to the opening of a savings account, which would include payroll deduction provisions and contingent access to funds. First of all, are you sure that it's possible to do that without a change in the law, particularly the contingent access to funds? And if these clauses are not what's necessary to make further progress, then why has more progress not been made, particularly with finding more partners with higher value work, which would enable these sorts of deductions and contributions to be made?
Yes, I am sure it's the case that the legislation is not required. We've had lots of conversations with the prison service who've been very, very reluctant to introduce the concept of real work. But I'm very pleased to see that Michael Spur, the head of the prison service, is now indicating that the core day, the restrictive hours with which that prisoners are allowed to work, will be relaxed. So that's very welcome. We don't think that the legislation that in here is very helpful. What we want to see is outside businesses bringing back to England work which has been offshore. I'm very pleased to see, for example, that BT has brought back its call centres. It's that sort of work that could be put into prisons, which could be done competitively inside prisons, which wouldn't take work away from local people. But it's got to be run by outside businesses. The central flaw here is that the prison service would still be running and employing the prisoners.
I'm sorry to push you, but specifically on the question of payroll deductions to open a savings account with contingent access to those funds, which would only, at the very least, would only be on release. Are you saying that could be done without legislation?
I absolutely believe it's what we did. We helped our employees, our prisoners, to open bank accounts. They then benefited from increased money within the prison economy, so they could buy extra bits and pieces within the prison. Most importantly, they could send money out to their families, because at the moment what families have to do is send money into prisoners, and if the families are on benefits, that's a huge tax on the families. I think the other thing that's missing here is support for families. I mean, if a man is earning a real wage in a prison, why shouldn't he be asked to keep his family? At the moment, there's a sleight of hand with the benefits agency, which means that they're not required to do that. They're not required to support their children or their families, and I think that's a huge mistake.
Yvonne Farg.
Chairman. Now, social welfare law is being removed from scope at precisely the same time as one of the hugest upheavals in the benefit system with the introduction of universal credit. What do you believe will be the impact on community cohesion and crime levels?
That's a difficult last question. But a good question, given the prison population. We know that they are likely to be the poorest people in our society. And I think there is a very important lesson here, really, for government, that if you're going to do criminal justice reform, you have to link that up to social welfare provision. You have to actually seriously think about joining up services and not having a separate kind of silo for justice. We think there's, for example, tremendous merit in the now rollout of the diversion and liaison schemes, which are going to enable people who are mentally ill, people with learning disabilities, to get the mental health treatment and the social care they need. If it exists in sufficient measure. And I think that's the point, that there are very many people in prison who are there because they've been failed by other public services. We wouldn't like to see a diminution in other public services, and we'd like to see a better joined up process. For those who do need to go to prison, more emphasis on resettlement and more emphasis on engagement of other public services, and also voluntary services, so that while they're in prison, the whole purpose of that period of time is spent preparing for a responsible life on release, which is the prison service mission, but very difficult to achieve in the current circumstances.
What I suspect will be the last question, Ben Wallace.
Sorry, it's just Mr. Chairman, if you a very actual clarification from Mrs. Francis Cook on the prisoner earnings thing. When you said you set up a business, etc., if I heard you right, you talked about voluntary. It was about a voluntary relationship between the prisoners and the prison service to deliver that business. Is that correct? I mean, there was no compulsion on the prisoners to do it.
I don't think it would be lawful or moral to compel prisoners to work. We don't have forced labour. It would be against the international law. We recruited our prisoners from the prison.
It wasn't on compelling them to work.
Okay.
It was about allowing to take from that earnings, if they oppose that, take some of those earnings and use them for something else. That would be the change of law that seems to be required.
Well, we did it. We as a condition of applying for a job with us, they had to agree to having 30% of their wages deducted, and we asked them, on top of that, to make voluntary donations to victim support, which they all did. I don't know how much they gave, because that was between them and victim support, but of course victim support benefited from the tax through gift aid as well, so they got extra money. So we've done it, and I didn't see any problem with it.
The key thing is that point, is that it doesn't... It's about the business and the prisoner making the agreement as a condition of employment. But it is, in that sense, it is voluntary. We're not forcing them to work. And the problem with the bill is it focuses it all on the prison service taking the money away. But our model, which we published a report on called Business Behind Bars, which we can make available to the committee, it looks at it from the point of view of the business makes the prisons themselves can agree with businesses the terms on which the businesses come in, and then the businesses find prisoners who are willing to work to those terms.
Andy Slaughter for a 5-second question and a 5-second answer.
Payment by result is really the only way that there's a suggestion of new resources going in. Are you concerned that that is the only way, and that may skew what alternatives to custody may be available?
We don't think that the only answer is payment by results, and we feel that it's an untested method. It may well prove to be an answer, but it won't be the only answer. I mean, if I can say in conclusion that what the bill seems to offer is the opportunity...
Order. I'm so sorry to interrupt the lady, but in accordance with the programme motion which the committee agreed, that brings us to the end of the time allotted for the committee to ask questions of our witnesses in this session. I'd like to thank you all very much indeed for coming along this morning, giving up your time and giving evidence.